Swayam Prabha. Digital India. Educated India.
Hello again. So earlier we discussed about the various anti-competitive agreement related prohibition, anti-competitive related agreements clauses in Indian Competition Act. So in this section, we will discuss about the provisions regarding the abuse of dominant position. So as you know so far, the being in a dominant position is per se not anti-competitive. The anti-competitiveness comes into picture when someone abuses its dominant position. So, section 4 of the Indian Competition Act prohibits the abuse of dominant position per se, and it has also categorized like what can be considered as an abuse of dominant position, by what behavior practices can lead to abuse of dominant position. So, the first thing is by imposing any unfair or discriminatory pricing. So, these unfair or discriminatory pricing can be as a can result due to the condition in the purchase or the sales of the goods or services, or it may also result due to the price in the purchase or sale included by following a predatory pricing for the goods and services. So, predatory pricing means placing the product in such a low price that it eliminates the competition as such. So, if there is a company who is having certain dominant position in the market and it has started selling the goods in a predatory price, then it may also lead to abuse of dominant position. So, the first was the first condition was that by imposing unfair or discriminatory pricing either directly or indirectly, it may lead to abuse of dominant position. The second point which has been specified in the subsection B of section 4 is the abuse of dominant position may if result by the limits or the restriction of the production of the goods or provision of services or market thereof. So, if there is certain condition by which there are limited the production of the goods, or means the production of the desired product, or the service is limited, is also a kind of abuse of dominant position. Also, there is like if it has prevented the development of the new scientific or technical advancement, or like new goods or services to the new goods and services to the consumers, it may also be considered as an abuse of dominant position. The in practices which may result in the denial of market access to other consumers or other competitors is also a kind of abuse of dominant position. And further, it makes conclusion of the contract subject to acceptance by other parties of supplementary obligations which by their nature or according to the commercial usage have no connection with the subject of the contract. So, if there are certain conditions in the contract which is like nothing in relation to the commercial usage and it does not have any connection to the product or the process in question, then also it is a kind of abuse of dominant position. So, basically it uses the dominant position uses its dominant position in one of the relevant market to enter into or to protect the relevant market, then it also a kind of abuse of dominant position. So, we have like these are the 5 clauses which has been specified in the subsection 4 of this Indian Competition Act, which like kind of gives us the idea when enterprise or a group of enterprise, like what behavior can be considered as an abuse of dominant position. So, here they have also further defined like what is a dominant position. So, in European context, we have also gone through this TTBAR agreements, and also like what are the provisions when certain market players are having shares less than 20%, or when the market when they are in the similar kind of goods or services, and when they are producing different goods and services and the market share is less than 30% in total, then they are exempted from any scrutiny from the anti-competitive behavior. In India, so far we have not defined those kind of guidelines. However, there is a definition of the dominant position. So, as per the definition, the dominant position means a position of strength enjoyed by an enterprise in the relevant market in India, which enables it to operate independently of the competitive force prevailing in the relevant market, or affect its competition or consumers or the relevant market in its favor. So, it is basically the behavior of the player which is which has enabled him to operate independently, or it has affected his competitors, or it has affected the consumers in the relevant market towards its favor, then it may be considered as a dominant player. And also like the inclusion of the predatory pricing. So, the predatory pricing is also defined in this act. So, this is just for your information. Like the predatory price means the sale of the goods or provision of services at a price which is below the cost as may be determined by the regulations of the production of the goods or provision of the services, with a view to reduce competition or eliminate the competitors. So, if something is sold at a very low price or a cheaper price, like which is which is possible by virtue that the player is having a dominant position, and which is not possible on behalf of the other players, then it is a kind of predatory pricing. So, it eliminates the competition because of this pricing, predatory pricing. So, these two predatory pricing or the other behaviors are like specified under which a company's behavior or a dominant company's behavior can be considered as an abuse of dominant position. So, it was not earlier specified like what kind of approach should be followed to judge whether the behavior is abuse of the behavior pertains to abuse of dominant position or not, whether we should apply the per se rule or the rule of reason approach. So, since it was not clear clearly specified, so the Raghavan committee report of the which was set in 1999. So, they gave a report in 2000, and they stated that there are certain key questions which needs to be asked before deciding whether the how the behavior can be adjudicated to be a abuse of dominant position. So, first they have listed the 6 questions which should be taken into consideration. First one is the how is the practice is harming the competition. Again harming the competition means it is reducing the competition, either it is through the predatory pricing mode, or either by restriction of any further innovation, or restriction or the sales of the goods and services. So, what is the practice which is hampering the competition, that needs to be asked. Second, the practice or the practice adopted by the dominant player, is it really deterring or preventing the entry of the new player in the market? That has to also need to be asked as well. Third, will it reduce the incentives of the firm and its rivals to compete aggressively? The practices adopted by the dominant position is preventing the other competitors from preventing the other competitors in making the similar product, or in in a level playing competition or not. So, that is also important questions to be considered. Then fourth one, which is the will it provide the dominant firm with an additional capacity to raise the prices. So, does it have if the dominant firm is having certain added advantage, maybe in terms of the IP or any technical advancement. So, does it that enables him to raise the price of that product, which is like not possible on the other players, like he has the monopoly over that particular technique or the product by which he can raise the price of the thing or not, that has need to be asked as well. Then fifth one will it prevent the investment in research and innovation? So, the dominant player is in such a powerful position that other players are not willing to enter into that product segment, like is it preventing the research and innovation in that area, or the dominant player is applying certain clauses that is restricting the further innovation to the by the licensee or not. So, these things has to be questioned before adjudicating that the dominant player is abusing its position. And the last one is, do the consumers benefit from the lower prices or greater product or services availability? So, is the behavior of the dominant player is helping the consumer in terms of the price or the nature or quality of the product or not? So, all these 6 questions must be taken into consideration before deciding whether it is a abuse of dominant position or not. Basically, these all are effect based approach in the application of the section 4 of this act. So, this is the recommendation of the Raghavan committee. So, also in the Indian Competition Act there are certain for certain provisions or certain conditions are already laid down by which one can basically the Competition Commission follows those clauses to determine the abuse of dominant position. So, basically in as per the our Indian competition law, the Competition Commission basically looks into the market share of the enterprise, like to determine whether a player is a dominant player or not. It first looks into the market share of the enterprise, then the size and resources of the enterprise, then size and importance of the competitor, like it is not only the player itself, but as well as the surrounding environment, its competitor, how the products market is spreaded by virtue of the like the firm or the entity in question or the surrounding competitors. Then the economic power of the enterprise, including the commercial advantages over the competitors, like what extra advantage the competitor is having in terms of IP or any other know-hows or technical advancement. The vertical integration of the enterprise or sales or services networks of such enterprise. So, this is also looked to determine whether it is a dominant player or not. Then dependence of the consumers on the enterprise, like how much the consumers are dependent on the enterprise, whether they can shift their loyalty to any other company or not. So, like we had already discussed earlier, like with if some company A is selling a product in 10 rupees and company B is also there which is selling the product in 12 rupees or 8 rupees. So, can I as a consumer consumer change my base from company A to company B or not? At what percentage or what is the probability that I will change my I will purchase the things from the second competitor or second firm. So, this is the kind of thing to which is taken into consideration to understand this economic power and what added advantage the competitor is having. Then also the vertical integration of the enterprise or sales, like we discussed that already. Then monopoly or dominant position, whether acquired as a result of any statute or by virtue of being a government company or public per se or public sector undertaking or otherwise. So, whether it is also very important to look into the factor that whether it is a government undertaking or a government company or a public sector undertaking, what kind of enterprise is it. So, so these are the things which are taken into consideration primarily to determine whether a company is a dominant player or not. And also further the entry barriers like the regulatory barriers, financial, then the risk of this product, marketing, technical and economical thing, like and how the substitution of these goods for the consumer is also looked into determine the dominant position. Then people's purchasing power, like how much of consumer, how many consumers are willing to buy those products if it is available in certain prices. Then market structure and size of the market, like what are the additional competitive product in that category where people may get distracted. Then social obligation, social cost, then the relative advantage by the way of contribution to the economic development. And this also depends on the nature of the case. So, it is the few list, these are the few parameters which has been listed, but again it may vary. So, the commission may take into account in all those provisions, or it may take few of this which is relevant for the product in question or company in question. So, this is these are kind of variables. So, all these are taken into consideration to determine whether a company is having a dominant position or not. So, first is to prove the company is having a dominant position, and second is to analyze whether there is abuse of dominant position or not. So, this is basically similar in line of the European Commission's competition policy, where first to establish the dominant position and then to establish the abuse of dominant position. So, if you look into the basic thing in both the country, by both European Union and in India, so the structure remain the same. Yeah, there are different depending on the nature of this market, the considerations vary, but the basic thinking or the basic analysis remains the same in both the cases. So, as a whole, so far we have dealt section 3 and section 4. So, the section 3 basically specifically dealt with the anti-competitive provisions and like various kind of agreements which may affect the competition in the market. And also it has listed out the, like it is stated that the prima facie the intellectual property rights are not anti-competitive, even though it gives a monopoly power to the owner of this intellectual property right, but it is not anti-competitive, and it has also laid all those intellectual property laws which are giving certain rights to the owner, and by virtue of that Competition Act like it is not, it will not be considered as an anti-competitive thing. So, and section particularly it established that, like as per the section subsection 5 of the section 3, like it simply removes the jurisdiction of the Competition Commission of India over the IPR related cases. So, when something is related to IPR, say the Competition Commission of India does not directly come into the picture unless there are specific condition. And further, the Competition Commission of India has created very strict standards, like to consider what kind of arrangement is necessary to protect the intellectual property rights, or to like for the purposes which has been mentioned under the section 3 subsection 5 of this act, and the particular provisions which are not falling under the protection per se given by section 3 subsection 5 is that the patent pooling kind of agreement, then the tie up arrangements, the agreements related to the payment of royalty after the term period of the agreement is over, or the agreements on the clauses of the restricting research or development, like when the licensee puts forward a condition where licensee can, when the licensor puts a condition where licensee cannot take forward the research and development on the technology transferred to him, or when there is an agreement which limits the usage of the patented invention, like for how many times or how many numbers of product can be prepared using the technology which he has licensed. So, all these things are out of this purview of the section, like out of the protection per se. So, undue restrictions on the licensee business shall be considered to be anti-competitive. So, all these provisions, like even though there are certain immunity related to intellectual property rights, but these which we just mentioned are not like immune from the provisions laid down under this subsection 5 of section 3. So, this is the basics of section 3 and 4 in similar line with the European Union. And in the next section we will also discuss about the various mergers and acquisition or combination agreements under which can be considered as an anti-competitive, or what is the status in the Indian competition law for those kind of mergers or acquisitions. So please stay tuned. Thank you.